Okay, Lindsay, are we pretty much everybody in?
Yep, everyone at the lobby is in, and we'll just keep trickling people in as they are logging in.
Okay, great. So quick heads up before we get started, we're going to be recording. So this is your opportunity to turn off your camera if you so desire. So ready, Lindsay?
Ready to go.
Okay, good afternoon. My name's Aaron Carmack. I'm the CEO of Cardinal Services. And with us today, we have Tomas Chavez, who's the head of our HR team. And we have Amanda Poe, who's their director of hiring. And actually, Amanda, I should just point out, was the former head of our HR team. And as so, they're both certified SMART, which, full disclosure, I am not. They're certified SMART with SHRM on here. So if you have questions today, there's a Q&A button. And it's kind of confusing, but there's also a chat button. Please use the Q&A button to put any questions in there, and we'll get those answered on here. Also watch for Amanda's going to be pasting in some links into the Q&A for various things, like when we get to the AI policy and links where you can go in there. And I saw a comment real quick for somebody was unable to hear. Lindsay, can you hear me?
I can hear you fine.
Okay.
Please comment in if other people are having trouble, or I'll reply back to her that you can call in on your phone too, maybe if her computer's having issues.
Okay, with that, let's go ahead and get started. So today we're going to be doing the 2024 Employer Legislative Update on here. So we're going to be covering stuff that's happening, of course, in Oregon, as well as federal updates, then proposed laws that might be of interest, and from our friends of the South, anything interesting in California that might be coming to Oregon. So let's go ahead and get started.
All right.
Amanda, I think you're muted on there. There we go.
Yes, it helps if I unmute. Can you hear me okay?
Yes.
All right, so let's talk about Senate Bill 999. This one kicks us off with one of my favorite topics, as well as our HR team's favorite topic, Paid Leave Oregon, otherwise known as PLO. And 999 was passed to fix and tweak some of the things so that PLO would more closely mirror and align with OFLA, which is the Oregon Family Leave Act. Spoiler alert, it doesn't perfectly mirror. It didn't quite work, but it got it closer. So let's not forget that all Oregon workers do get Oregon sick time, but for those who work for larger employers, they can qualify for protected leave under OFLA or the Federal Family Leave Act, which is FEMLA. So OFLA and FEMLA give you job protection, but OFLA and FEMLA are unpaid time off. So unless you have vacation or sick or other paid leave, your time off under OFLA and FEMLA are unpaid. So PLO provides paid leave for 3 reasons, either the birth or adoption of a child, the employee's serious illness, or the serious illness of a family member, or safe leave. So PLO applies to employers with only 1 employee or more, so every employer. OFLA applies to employers who have 25 or more employees, FEMLA 50 or more. PLO and OFLA overlap in many ways, but PLO doesn't cover things like bereavement leave or sick child leave like OFLA does. PLO doesn't cover military family leave, and it doesn't cover leave for less than a full day. So PLO has to be taken in full day increments. And there's definitely some quirky differences between all the different leaves. But let's get back to 999. PLO gives qualifying employees generally 12 weeks of leave. I could say in general, they can take leave as of their first day of work, but it's not until the employee is at their 90 days that they have actual reinstatement rights. So under PLO, employees can take PLO again in their first 90 days. They can take it, but you don't actually have to hold their job for them unless they've been working for you for 90 days. So under 999, when PLO is taken, the leaves are to run concurrently, and there are some opportunities for stackable leave. So let's talk about how the leaves are taken and who administers them. The Oregon Employment Department actually administers the PLO. PLO is completely employee driven, meaning the employee must file, they must notify the employer, they must apply with the OAD, and the OAD determines if the employee qualifies, if the leave is approved, or if it's denied, and they notify the employer. The only information that the OAD will tell the employer is if they tell the employer when the employee applies, then they tell the employer if they're approved or denied, and then they tell the employer what the dates are. Now, OFLA and FMLA have always been and will continue to be managed and administered by the employer. So if you come play with Cardinal, we take care of that for you. So again, PLO and OFLA have different types of leave. They're similar, but not quite the same. They're closer. So it's clear as mud, right? Let's move on. Let's give you a couple scenarios. So let's start with an easy one. This is what we refer to as a normal, perfect PLO situation. In this diagram, you see PLO, FMLA, OFLA, and the employee's name is Sally. Sally's been employed for over a year. Sally has a baby, and she requests to take 3 months off or 12 weeks, since we're actually counting weeks under the leaves. The employer has 60 employees. So for simplicity, this is an OFLA and FMLA covered employer. And we've determined that Sally qualifies for OFLA and FMLA. Sally applied for PLO through the OED, and Sally was approved. So we notified Sally that we're going to designate her PLO time off as OFLA and FMLA, and we're going to run it concurrently. So that's pretty simple, and I'm sure that this is exactly what the Oregon legislature had in mind when they wrote all this out, and they wanted to keep it simple. So here's where it gets a little interesting or a little more complicated. Let's look at a different scenario, but the same scenario. So Sally decides to take OFLA before the birth of the baby due to some pregnancy complications. So she's taking 12 weeks off for pregnancy disability leave because of those pregnancy complications. We've already determined that this is an OFLA and FMLA covered employer, so we're running both OFLA and FMLA concurrently. But remember, PLO is only activated by the employee. So Sally knew that there were complications and that she might need to take more time off, so she waited until after the baby was born to apply for her PLO, which is totally her right to do. Once the baby is born, both mom and baby are healthy. Sally applies for 12 weeks off under PLO for her parental leave. It's approved, and now that time is stacked. So her total time off is 24 weeks. It's all protected time off, meaning Sally's job is protected, and she returns to work after 24 weeks off. And we're not even getting into the scenarios where the leave can be extended beyond that.
We'll get into a little bit of that scenario right here. So I get scenario number 3, and now I want to start by saying, even though this is going to seem complicated, please keep in mind, we're not going to talk about intermittent leave, so these can be infinitely more complex, unfortunately. So in this case, we have the same employee, Sally, and the same employer, so they, again, are qualified for OFLA and FMLA. Sally's qualified for both OFLA and FMLA. And in June, she's pregnant, and her and her doctor decide that she needs to take some pregnancy disability leave at that point. So she applies for OFLA and FMLA with the medical certification and is granted that. She's been out for about 8 weeks at this point when she has the birth of her child. So birth of her child happens in August, and that triggers her to file for leave under parental leave. So that'll offer her an additional 12 weeks of OFLA. For a total of 20 weeks of OFLA. You see here, the FMLA line stops after 4 more weeks. That's because under the federal guidelines, FMLA, you only are granted 12 weeks per year. So she's done with her FMLA after those 12 weeks until June of the following year. So you fast forward about a month, and in September, Sally realizes that money's getting a little tight, and she remembers, oh yeah, I can apply for that new paid leave Oregon. So she does. And she is approved under paid leave Oregon in this case for parental leave of 12 weeks. So that triggers a 12-week leave for her starting again when she applied in September. And so she's off for another 12 weeks. At the end of that 12 weeks, she remembers that under PLO, you are granted any time you take paid leave Oregon and it's running concurrently with OFLA, it extends the OFLA benefit from 12 weeks to 4 additional weeks to 16 weeks. So at the end of her paid leave, she can now take an additional 4 weeks of OFLA unpaid leave. That is her right. So she will now have taken a total of 24 weeks of OFLA. Remember, that's 8 for her pregnancy disability and 12 plus 4 for her parental leave. And she'll have taken 12 weeks of PLO. Some of that did overlap with her OFLA. But in this scenario, you can see where an employee can start to stack that leave and be out for an extended amount of protected time. All of this leave is completely job protected. So again, what we really want to hammer home here is that Paid Leave Oregon triggers 16 weeks of leave when it is in conjunction with OFLA leave. And these little red and blue lines show you that it can be less paid leave, more OFLA, half and half, more or less. Point is, it's 16 weeks total. So when someone's on OFLA leave, OFLA leave, and they are granted paid leave, you need to immediately think of that trigger. They are now going to be able to get 16 weeks total. And if you use Cardinal, we have you covered because this is what we're doing every day.
Fortunately, not every day.
Well, most days.
So some key points with the PLO on here. Remember that the PLO is employee activated in the employment department. They tell us the dates. Whereas OFLA and FEMLA, that's on the employer. The Cardinal HR team handles that for you. We're running OFLA and FEMLA concurrently where we can with the PLO. And also we have to determine each leave and then track each one of those separately, remembering though that the PLO can trigger more OFLA leave on here. And this, as Amanda and Tomas have really alluded to, this is really just scratching the surface of this. We could go on for probably an hour just talking about PLO and some of these different scenarios in here. I personally can't do the stackable leave without mapping it out and then doing research every time on this one. And things like Amanda had mentioned that the PLO Senate Bill 999 doesn't completely match up these two, OFLA and the PLO. So something like bereavement, and I'm having to scratch my head and go, is that under FMLA, PLO? Oh, no, that's just under OFLA on there. So you always have to be careful of those type of issues here.
All righty, you say you could talk for an hour about it. I could probably talk all day about PLO. So let's move on though. Let's talk about the measurement period. So under PLO, under that Senate bill, there was another change. I just want to point out Cardinal does utilize a measure forward leave year. Under that same Senate Bill 999, employers must use a measure forward option to establish their OFLA leave year. So historically, there were a few different options an employer could use for their leave year, such as a calendar year or a fiscal year. But effective July 1st of this year, you must use that measure forward year, and this is to align it with PLO. If you currently use a different leave year method, you need to change your policy. And you need to notify your employees at least 60 days in advance that you're changing your policy. So we would recommend that you update your policy in your handbook sooner than later. Give us a call. We can help you with that. Again, if you co-employ with Cardinal, we already utilize that measure forward leave year. We've got you covered.
Okay, and one situation that we are seeing happen a little bit more, under PLO, employees are required to give notice. Generally. That said, there are certainly situations that I'm sure we can all allude to where notice isn't always available. You didn't know something was going to happen and you suddenly need to take this leave. So in those scenarios, it's the employee's right to ask for the leave, apply for the leave through OED. The employer, again, has no power to stop them or help them or do anything they can. So the employee applies for the leave, they go out on leave, and then it takes about a week to get a response from OED. So in the cases when OED gets back to you and says, I'm sorry, your leave is denied, what do we do? the employee's been out. Well, the first thing you want to do is interact with your employee and try to get them back to work as soon as you can. And hopefully you have some established attendance guidelines set up in your handbook or otherwise, and you want to stick to those and use any precedent that you have to get the employee back to work as soon as possible. There unfortunately are no black and white answers. There's no roadmap. You want to use your policies and make sure you have good, strong standard policies available when this happens. And if that means you have to discipline an employee, that may be the case. But again, their policies are what you want to stand by and use any precedent that you've set in the past.
Alrighty, I did just pop a link into the chat with some more information about paid leave Oregon. So let's move on. That's enough about paid leave Oregon for now. Let's move on to Senate Bill 851. Bully did publish a model notice. The bully workplace bullying poster is optional. At this point, there are no legal requirements. The employers have to post it, but this does seem to be a bit of a hot topic. Let's see, bullying, it's not really illegal in Oregon. However, it is very harmful. And in some cases, it can lead to lawsuits based on discrimination. So bullying is not good to have in your workplace. There does seem to be quite a bit of bipartisan support around this topic. OSHA has been following up on more of these issues. And just a heads up, we do expect more to come out on workplace bullying in the future.
Helps to unmute myself. So Senate Bill 907, this is an update to the Oregon Safe Employment Act. And as you see in the second sentence on here, it allows employees to refuse to do unsafe work. And who doesn't like safety? But if you read the next one, with no reasonable alternative and in good faith, an employee could say, hey, I don't want to do something because I think I can be injured, seriously injured, or killed because of that on here. So the concern with that, when I was first looking at that, and really set off the alarm bells in my wearing the HR hat on here, that with no reasonable alternative and good faith, it's creating a new ambiguous standard that relies on the individual employee's perception, not whether it's safe or not. So it could open the door for extensive litigation over what refusal is reasonable and what isn't. And I was starting to doom scroll down, looking at different scenarios. And for example, I thought of an ER where by the time it becomes apparent whether or not the employees met the burden of proof for acting in good faith and being reasonable, a patient could be harmed. I thought about our contractors we work with. Just because the type of work is dangerous doesn't mean that it's unsafe. Safety is about mitigating risk. It's not where looking at are there proper safety guards in place. So this first part of it, no reasonable alternative and in good faith, is all about that employee's perception. I read a little bit further onto this bill, and it requires the Director of Department of Consumer Business Services. So Oregon OSHA is part of DCBS. So it requires Oregon OSHA to come up with provisions in accordance with this first part under the federal OSHA on there. Federal OSHA, that's all about safety. Is it safe or not? Whereas the first part isn't on here. So Oregon administrative rules are being written, and I was kind of concerned what's going to be coming out of this. So I did reach out to a lobbyist on here and said, well, full disclosure, a pro-business lobbyist, and his organization supported this bill. So I said, well, what's going on with this? Having these two opposing viewpoints in there. And he said, well, Senate Bill 907 was going to pass, so we tacked on that last part about it complying with federal OSHA, called it a win on there. So hopefully the administrative rules that come out are more about safety and less about individual employee perception.
Okay, House Bill 2649. So this one requires public contractors to change their apprenticeship requirements when they're in public works contracts. So it increases the percentage of apprenticeship hours from 12 to 15%. So it's really important to note that this is an aspirational target. So if you have those contracts and you haven't hit that 15% of apprenticeships mark, it's okay. You don't have to cancel. You just have to be able to show in good faith that you attempted to get there. And if you did that, you should be okay. But, slight raise, 3%, and yeah, it should be a good thing.
All righty. So beginning January 1st, we have House Bill 3443. Oregon's victim protection law now includes victims of bias. So also commonly referred to as a hate crime. Let's see. This law now includes bias crimes in the definition of safe leave under PLO. So safe leave is one of those reasons that you can take your paid leave. Under paid leave Oregon, safe leave is for survivors of sexual assault, domestic violence, harassment, bias crimes, or stalking. And just a reminder, in Oregon, we already have crime victims leave. This just adds bias to that policy. So it expands upon Senate Bill 577, where employers are prohibited from discriminating against an applicant or an employee before or during employment because they're a victim of bias, and must provide reasonable safety accommodations upon request. Examples of a safety accommodation for a victim might include modifying their schedule, giving them a different start time or end time, installing some sort of lock on a department door or an office door, changing their phone number, changing their extension, moving their workstation to a different location in a building. If you haven't reviewed or updated your policy yet, now is a great time to do that.
Okay, and let's talk about House Bill 3471. So this bill makes it unlawful for an unlawful employment practice for an employer to make an offer to negotiate a settlement agreement contingent upon the worker entering into a no rehire provision. So what does that mean? Well, an example I can give you. So employers, they can't require employment releases that indicate no rehire provisions, and they can't do that even as part of workers' compensation settlements. So you can imagine an instance that it would occur where the employer is no longer able to safely work at a job because they sustained an injury there, right? They had an injury on the job. And in the case of that occupational disease, which is what they technically call that injury, returning to the job site's probably going to re-expose the employee to whatever that exposure was. And there's a prospect there that another workers' compensation claim can be filed for the exact same issue. So it's a little tough there that you can no longer say, hey, you can't come, we're not going to have you back, but we need this no hire provision. That's not legal any longer. And we'll see if this one comes back around. But as of now, that's where it stands.
Let's talk about rounding hours now. So Oregon law says that employees must be paid for all hours worked. And rounding's been used for years. It was designed to make calculating time more practical in days before everyone had some sort of supercomputer in their pocket. So everyone has a device nowadays. Computers are everywhere. Rounding typically works by using the 7-minute rule. So minutes 0 to 7 are rounded down, 8 to 15 are rounded up, and you're rounding to the nearest quarter of an hour. That's the most common method that employers use to round. And the conventional wisdom is that neither the employee or the employer are disadvantaged because the pay balances out in the end. So an employee can be underpaid when the time is rounded down, but they'll be overpaid when the time is rounded up. So in theory, it should all even out at the end of the pay period. And this method of rounding is totally allowed under federal law. However, a recent federal case says that rounding is prohibited in Oregon. So in that case, that employer used a system that rounded to the nearest quarter of an hour. And that federal judge said that Oregon statutes require payment of wages for all hours worked, which is in direct conflict with what the rounding that's allowable under federal law, since sometimes employees would not actually be paid for all their hours worked when the time is rounded down. So what now? Well, under this new case interpretation, employers must pay employees based on their actual time worked without rounding. All employers are encouraged to promptly review how your timekeeping system works. how you use your time cards, including and telling your employees you have to instruct them to actually report their actual time worked to ensure that you're in compliance and avoid potential wage and hour penalties in the event you have a wage claim. If you do choose to use a rounding system, which you can still use, you have to ensure it always favors the employee so that you can still round. You just have to make sure that it always favors the employee. So we have seen a huge trend recently of employers moving away from paper time cards and moving to online timekeeping systems. There's many options out there, even smartphone apps. So if that's something you're interested in, just let us know. And next, let's talk about Oregon Saves. The final deadline is passed for enrollment for Oregon Saves. This has been around for a while. Enrollment started with the larger employers way back in 2018. Now, as of July 2023, all Oregon employers are required to be registered. We did take a quick look at the rules. There aren't any penalties outlined, so we really have no idea what they can do to penalize you until they're actually outlined in the Oregon administrative rules. But Oregon Saves is not your only option. Cardinal Nest Eggs is included in at no additional cost when you combine your payroll processing with Cardinal. So give us a call and we can either help you get registered or help you file as exempt.
And moving on to artificial intelligence policies. So if you have knowledge workers, you probably need a policy, and here's why. So let's say you have a knowledge worker and they have an email string that they need to answer some questions to. Well, they can take that entire email string, copy and paste it into an AI. So think of like ChatGPT, and they can tell ChatGPT, hey, come up with a response to this. And in fact, ChatGPT, I want it to be 2 paragraphs long, and I want it in a business casual style, so it makes it look like it comes from me. And ChatGPT will do that. Now, what I've found is that it'll do about 60% of the work on there. You still have to know all the little details and make some changes, but that's a huge improvement in productivity on there. So you may have employees already doing this. The problem is with this is, what are the terms of service with that AI? Do they own the data that goes in there? Can they use it for whatever they want on there? So you may, in that email string, maybe you have proprietary information. Maybe you have medical information that could violate HIPAA. Maybe it's your pricing structure you don't want in there. So what can you do? Well, Cardinal, and I think Amanda's going to be putting this into the chat. There's a link to an AI policy. We've created one that gives you 3 different options. No AI use in the workplace. Second one is AI use with management approval. And the third one is everybody gets to use AI. And full disclosure on here, I used AI to help come up with this policy. Once again, it did about 60% of the work on there, but I had to have enough knowledge and experience to say, okay, well, this belongs in there. I need to take these pieces out, but it was a huge time savings on there. So AI is not going to quite replace employees yet.
But it sure has made our job a little bit easier. Aaron's rubbed off on me on some of that AI usage, I'll admit. Okay, so into a federal statute here, Secure Act 2.0. So the Secure Act 2.0 made a few changes to most folks' retirement accounts. The age to start taking your required minimum distributions, or RMDs as they're referred to, has increased in age to 73 years old as of 2023, and that'll increase again to 75 years old in 2033. Also, catch-up contributions will increase in 2025 for most plans like 401k, 403b, government plans, and IRA account holders. Defined contribution retirement plans will be able to add emergency savings accounts associated with a Roth IRA account. And so, it's a lot of technical speak, and I'll admit, Cardinal has a fantastic benefits team that deals with all of this for us and for you if you're a Cardinal client. So we'll be making sure we implement all these changes with our plan administrators, and we can do the same for you.
So moving on to the employee retention tax credit. late last year, the IRS put a moratorium on the employee retention tax credit. And the reason for that is these ERTC mills. And the IRS has been posting up a bunch of stuff on their websites, putting out advertisement. I even think they have a commercial that came out on this. And there's a lot of, what their concern is, there's a lot of places that are not accountants, not CPAs, and they're going to employers and telling employers, and if you've been an employer, you've probably been inundated with phone calls, with emails saying, hey, you're pre-approved for this big pot of money, and just file with us and we'll take care of that. And we'll take a percentage, sometimes 10, sometimes 25% of that. And the IRS is pointing out that, hey, places that should be helping you should be accountants, should be somebody who's certified smart and knows how to do this. They shouldn't be taking a percentage of the fees. They should just charge a standard fee. That's another red flag that maybe something's up, because if they take a percentage, they're incentivized to say that you actually qualify on there. So I keep expecting that moratorium was lifted on January 1st, and I keep expecting some material to come out of this. And well, what is the IRS going to do differently? Because last check in December, there's over 1 million forms just stacked up at the IRS, and literally stacked up because they're still using paper on that. Well, since then, the beginning of last week, there was a bill introduced in the House of Representatives, and I think that it got through Ways and Means at 40-3. So there seems to be some bipartisan support. There's also sponsors in the Senate. Now, I have no idea how that bill will eventually come out, but they're looking at closing down the ERTC as of the 31st on here. So just not sure what's going to happen with it. There may be some amendments to that, but we're certainly keeping an eye on it because of this huge backlog with the ERTC.
Okay, and just a note that 2023 was a long session for the Oregon legislature, and 2024 will be a short session. So that means there'll probably be fewer bills, and there'll be some time spent looking back on the bills that didn't pass in the previous session. And one of those bills that didn't pass in the previous section is HB 2057. And now this measure would have made general contractors liable for unpaid wages of their subcontractors. That's the easiest way to understand it. General contractors would have had to basically police and take responsibility for all of their subcontractors' misdoings with regards to paying their employees correctly. And then another one that didn't pass is House Bill 3205. Now this one fell under Oregon's Equal Pay Act, and the Equal Pay Act says that employers may not pay employees any differently if they perform work of a comparable character. So unless the pay difference is based on a bona fide factor like seniority or education or experience, all the pay must be equal, and so that it became a problem. Effectively, it prohibited hiring and retention bonuses, which further exacerbates labor shortages for a lot of employers. So again, this didn't pass. I anticipate it'll probably be brought back up because this can be a thorn in the side of a lot of employers who want to offer things like relocation bonuses, retention bonuses, things like that help us find staff.
So the SAFE Corporation, the workers' comp carrier, they're working with the MLAC, which is the Management Labor Advisory Committee. So MLAC is a group, half management, half labor. They advise the legislature, and generally what they recommend, the legislature takes pretty serious, oftentimes passes and goes into law on here. So SAFE is working with MLAC, and they're working on a bill for employer workers' comp fraud on here. So a little bit of background, employers committing fraud is generally considered an administrative offense, usually on here. And employer fraud on the workers' comp side makes the non-cheats pay for the cheats. And so think of it like your auto insurance policy. You pay for auto insurance, but you also pay for that uninsured motorists on here. So SAFE and MLAC want some accountability, and all good so far, right? So I did attend the MLAC session where this was introduced. And from a big picture, what I've seen is that workers' comp carriers do a good job of auditing. If you've ever gone through an audit, I realize that if you're co-employing with Cardinal, we're doing most of the audit work on here. But if you've ever gone through it with them, just with the auditor, they almost always find something wrong on there. It just seems like it's always a pain to deal with that on there. So if we get a law, what level of misrepresentation is going to be fraud? Because we don't want a system where someone makes a clerical error and goes to jail. They're very aware of that concern, and that's what they're wrestling with, is that level. So I'm going to continue attending the MLAC sessions, give input from an employer standpoint, and report back. I don't expect there to be any law in 2024. I suspect it's going to be introduced in 2025. So there's a ballot measure. I did want to mention this one. There's a lot of signatures being turned in on it. So I'm assuming, but I'm no expert to be able to tell, that it's going to go to voters. And what this is looking at doing is raising corporate taxes, putting in a minimum of 3% on employers, or on corporations rather, not just employers, on corporations with revenue of $25 million or more.
Okay, now I get to talk to you about California updates. I'm in California. I am Cardinal's Director of HR, and I do work for all of our clients in different states. However, I started out and still am located in California. And as we know, our two states like to mirror one another back and forth when it comes to employer guidelines and things of that nature. So California has a couple really big changes this year. We are going to be required, as of April 1st, all employers in the state will have to have a workplace violence prevention program. This is to be modeled somewhat like the currently required injury and illness prevention program, but this is obviously going to focus on violence in the workplace, and not just internal, but we're talking external. You know, how are you going to keep your employees safe from your customers, from each other, all those things. Interesting thing here, this is going to be policed by Cal OSHA. I am a part of another group, and I actually have a Cal OSHA presenter coming to present to our group in March, about 2 weeks before the implementation of this bill, or the requirement for the bill, which is April 1st. And I asked that presenter, I said, hey, can you please talk about the workplace violence prevention program? This is going to be great for all of our attendees. And they said no. And they said no because typically those at the top will change their mind up to the last hour of how this is going to look. So unfortunately, we're not talking about it until we release our sample plan, which you can expect on April 1st. So it's left a lot of California employers, you know, a little nervous, and just a story, an anecdote. It's pretty typical of what our states like to do when they come out with some new rules. Then the other big one that's passed in California is cannabis or THC prohibitions. You can no longer deny someone's employment or end someone's employment for use of cannabis or THC in their system off the job. So what does that mean? It means all drug testing in the state, if you want to drug test someone for THC, you can only do it through a metabolite test, which is an oral swab. No more urinalysis for THC, because as many know, it stays in your system for a long time and you can't tell when the use happened. So California is trying to make it so that employees can do what they want recreationally away from the job and not pay any consequences on the job. So it's a big one. We've already changed that here in the California Cardinal office. We do oral swabs for drug screening now, and I could see something like this come into Oregon soon.
Yes, I wouldn't be surprised if that doesn't come to Oregon soon, because it also came to Washington this year. So our sister state right north of us also recently passed legislation very similar to that. So stay tuned. We're watching that one too. There were a few questions that came through in comments. There was a comment in the chat. There is someone who loves AI as a tool. It has improved their efficiency greatly. I did drop some links in the chats also about Oregon Saves and Paid Leave Oregon, AI, and then also the California updates. And then in the questions here, I'll just kind of go over those. We did answer those as they came through. Is PLO paid by the employer? No, it is paid by the state directly to the employee. Employees apply for it through their Francis Online portal account. Very similar. It's paid out very similar as to unemployment. Employees apply for it. There's a formula they use to calculate how much they earn. It is funded by payroll contributions that are funded by the payroll deductions on our paychecks. It's a very small deduction. And then also there's also an employer contribution, which is based on your employer size. So that all started a while ago. Most of us didn't even notice it on our paychecks. So is PLO only applying to pregnancy? No, there are actually 3 reasons that someone can take a paid leave Oregon, and that's for family leave, and then also medical leave and safe leave. There's three different types of leave. And does an employee just have to claim bias or not have any proof? How does this work? So under PLO, the OAD will require proof to substantiate their request to take safe leave as using bias as their reason. So anytime an employee does request PLO, they do require documentation. So there will be doctor's notes required by PLO. And if the doctor's note does not require all the required information that they want, they will deny the leave. If it doesn't have the exact dates or the exact reasons, or it's not signed, they will deny the leave. So, and as an employer, if an employee is requesting a reasonable accommodation, you'll use that interactive process, just like you would for another, like a medical request for an accommodation. And then Erin, this looks like a question for you. For MLAC, is that in favor of the employee or the employer? And what if the employee committed fraud?
Great question. So MLAC is equal numbers of management and labor. They are appointed by the governor. So they're supposed to be representing both sides of the equation and coming up with a overall consensus of something that is going to work for both sides of this. That's the theory behind it. And it's actually been pretty successful in Oregon when you compare Oregon to, no offense to Tomas, but California and its mess of a workers' comp thing. I think I can safely say that on there. So the other piece about employees and workers' comp fraud, this is an interesting topic. Oregon does a terrible job at workers' comp fraud with employees. On average, Safe Corporation, which is what 60, 75% of the workers' comp market out there, they refer every year, they refer 3 to 6 employees to law enforcement. And that's just referring them to law enforcement. Whereas I was picking on California earlier, California has some pretty strict policies and people go to jail in California for workers' comp fraud. So it's a much different thing. So that piece about the employee fraud is not being discussed at this point. So did I cover everything on that, Amanda? It was kind of a long-winded answer.
I think so, and I don't see any follow-up questions to that topic. I did see one more question pop up. Can an employee use the FEMLA in place of sick pay or vacation pay when they were recovering from surgery? So if someone's recovering from surgery, that sounds like it was probably some sort of serious illness. So in theory, they probably qualify for FEMLA. FEMLA is the federal medical leave, which is an unpaid leave. And FEMLA applies to FEMLA covered employers. So if you have 50 or more employees, but FEMLA is an unpaid leave. So I'm thinking maybe you're asking about the PLO. And so PLO, yes, would replace their wages and they can use that instead of their vacation pay or sick pay. So when it comes to PLO, it's the employee's option to use PLO or their paid time off. And when it comes to FEMLA or OFLA, it's the employer that gets to determine if the employee should use their vacation or sick time. And then do we know how short-term disability policies are working with PLO as a rule? Well, that's a great question. Erin, have you come across that question?
I have not come across that because my understanding is a lot of those were going away except for high earners. Mm-hmm. Where the example that I'd heard was, let's say you have a group of anesthesiologists and the maximum pay on the PLO was much below what they normally would earn. And so they went with having short-term disability on top of that. But I haven't, beyond that type of example, I haven't heard of anything. Tomas, I don't know if you've heard anything.
I have not. As soon as I saw that, I thought, oh, something else for us to look into. Thank you.
Yeah, that is a great question. Reach out to the carriers. All right, I don't see any more that have trickled in.
Okay, well, if there's any questions that come up in the future, remember just to contact the HR team, hr@cardinal-services.com with any questions on here. And with that, I appreciate you sticking around, watching this video. And Tomas, Amanda, and Lindsay, I should mention, thank you for running things behind the scenes on there. And with that, have a great day, everybody. Thank you.
Thank you.
Thank you.